Good evening, professionals. In our 10th corporate law webinar series, we have been discussing about the provisions relating to intellectual property laws. To begin with, we have started reading and understanding the provisions relating to Patents Act. In patents, we have had a couple of webinars where we have discussed threadbare about various provisions under Patent Act, and last week we just discussed about an interesting provision relating to compulsory licenses and patents, in which we have also studied the recent judgments, the various judicial pronouncements passed by Supreme Court, High Court, and we also studied the one and only compulsory license granted to NATCO. Today, we are going to discuss another interesting topic, Chapter 17 of Patents Act, where it talks about the usage or acquisition of such patented process or product by government for its purpose. Section 99, 100, 101, 2, 3 discusses in detail about the various aspects where it will be used for government purpose or the rights by third parties or where it could be acquired by government. The same Supreme Court order dated 30th April is going to be applied in this particular case as well, where the COVID vaccines, we are going to see how effectively it could be used for government purpose. Last week, Supreme Court in its order discussed about how this particular COVID vaccine could be provided compulsory license considering the emergency situation which has cropped up. And today, inter alia in the same order, the Supreme Court has passed the judgment on how these vaccines could be used for government purpose, taking reference to section 100, and they've also mentioned about this particular 102 where it could also be acquired by government. So we are taking reference to the same Supreme Court judgment, and in response to this particular order, there is also an affidavit which is submitted as latest as 9th May 2021 by central government in response to this order. We are going to see that also in brief. And the High Court order, which we already discussed last week, but since there is a reference again drawn to usage of such patented products by government, we are going to take a cue of that High Court order as well. A sincere thanks to Aishwarya and Hari Santoshi for this presentation. Some of the legends used in today's presentation. The schema, we will first see section 99 and 100, the usage of any invention for government purpose. Then we will see the rights exercised by third parties and acquisition. This particular patented product or process could also be acquired by central government. We will see what are the conditionalities ascribed to it, and when High Court intervenes. Of course, when the matter is not getting settled, then the High Court intervenes. So we will see the reference to the disputes to High Court under section 103, followed by which we will see the Supreme Court High Court order and response by central government. First, usage of invention for government purpose by central government. Section 99 defines an invention which is used for government purpose as something which is made, used, exercised or vended. Vended means offered for sale for government purpose, or it could also be your government undertaking. Chapter 17, however, does not apply to grant of patent under section 47. Friends, when you read section 47, we have already discussed about registration and grant of patent, where under 47 you had lot of conditions where such grant of patent could be given. Two such conditions talk about any manufacturing material, apparatus or article, or any other article which is ideally a product, or any article which is made out of the process, the patented process, and this is basically imported or made for the government's own use, that is for their self-consumption. Or the second line, subsection of this 47 also talks about grant of patent subject to the condition that any process, any patented process is being made used by the government for its own use. So these two sections, since there is a specific section which draws reference to these two provisions on government's usage, that is carved out under this chapter 70. Section 100. Section 100, very important provision for chapter 17, which talks about use of invention for government purpose by central government. So when the government can intervene and exercise its prerogative right to use a patented product or a process. They can use the invention once after the application for patent is made. So the time when they can do this particular act is after the application is made or after the grant of patent. Second, 100 subsection 2 talks about the situation where this particular use of invention is made before the priority date of relevant claim. So what happens when such particular product is either recorded or tested or tried by or on behalf of the government or government undertaking? It could be made free of royalty. So when it is going to be, so the incidence in this particular case is before the priority date of this claim. If that is the case, ideally there is no grant of patent and hence government could use that particular product free of royalty or without even remunerating to the patentee. Thus, 100 subsection 3 talks about the succeeding event, which means once the patent is granted, what happens then? They have to be remunerated because patent holders' right has to be protected. It involves a cost because they have done this invention. Thus, they have to be remunerated as may be agreed between both the parties. Who are the agreed parties here? Agreed parties will be one, the central government or the authorized person, and the patentee. The other party will be the patentee, who is the interested party to the contract. If they are not coming to a consensus, then it could be decided by High Court. So, for the use of such patent, patentee shall not be paid more than adequate remuneration. So, it should be not exceeding the economic value of the patent use. And this patentee, the reference drawn to him also includes your assignor or exclusive license. So this is described by way of a flow chart just to have a snapshot of what we have discussed thus far. 102 before priority date, 103 after the grant, 102 it could be free of royalty, 103 adequate remuneration has to be compensated for as per either the contractual terms or as intervened by High Court and determined. Here, for before the priority date, otherwise than in consequence of any communication by patentee or any person from whom he has derived the title. Ideally, he could be then an assignee. After the grant of patent, it could be on any communication because his right is affected. Hence, it could only by way of communication to the other party and not otherwise. Now, we move on to 100 subsection 4, where CG may authorize in respect of an invention. It could be 1, either before or after the grant of patent. 2, it could be directly or indirectly authorizing the patentee or applicant. Or 3, it could be either or after the act to any person by which it is authorized. So, CG is empowered to authorize such an invention. For what purpose? It is for the purpose of, again, your section 99, where you could make, use, or it could be exercised or vended such material or apparatus or other patented article or process. And then comes notification. 105 deals with notification. So when such invention is used for this government purpose, you need to certainly intimate the party who is affected. Who is the affected party? Patentee is the affected party. When does it occur? In case of national emergency or extreme emergency, or it could also be for non-commercial use. Friends, why does the government intervene? Any common man will not be having the wherewithal to go and make the payment for all these patented products which has a cost attached to it. Hence, government intervenes so that the common man will be benefited. So that is the reason COVID drugs. All common public cannot afford to go and buy all these COVID drugs and vaccines, be it your injections and other COVID vaccines. So to provide them the necessary remedial steps, it is suggested that government intervenes. And 100 subsection 7 also clarifies that 100 subsection 5 notification also draws reference to your exclusive licensee or assignor, which means patentee also includes your assignor or licensee. And finally, they say this right of government to use this product for government purpose also includes the right to sell it on a non-commercial basis. So they also have the right to sell it on non-commercial use. Next comes your right of third parties. This is again very interesting, friends, very important as well. Here, section 101 clearly says that with regard to this patented invention, in respect of which an application is pending for the purpose of government use, either by the central government or its authorized person, or in the second instance by the patentee or an applicant, in which case the provisions of any assignment shall be of no effect. For instance, I am the patentee and I am assigning the right to Aishwarya. So in this case, she will be the assignee. There will be one agreement which is called the deed of assignment. So in that deed of assignment, even if I am going to say that this assignment is valid and binding for Aishwarya, and this is not having, this particular assignment does not extend for any government use, though there will be some restrictive covenant imposed in this deed of assignment, I am forbidden from doing that because 101 is superseding this power specified in your deed of assignment. Hence, this particular provision as mentioned in your deed of assignment or any agreement between the patentee and applicant will not have any binding effect as long as it curbs the right of the government to use this particular patented product or process. And this also does not lead to infringement of copyright, is very clearly driven in 101. Thus, it is again described by way of a flowchart, friends. The true owner is assigning the patent or right to apply for or obtain patent, which is assigned to the patentee, assigner, assignee. How the contractual term comes? By virtue of a deed of assignment. And where is it getting used? It is used for the purpose of government. And what is the remuneration? Because any contract requires a consideration, the sum payable. So government is using it, though they are the beneficiary to this particular contract, they have to certainly pay some amount. And this particular sum payable by the government to the patentee shall be divided between the patentee, that is this assignee, and also the assigner. So they shall mutually decide and determine the particular remuneration. If there is going to be any dispute, then we already discussed that the High Court will intervene in this matter. So if any exclusive licensee is authorized to use the invention for the purpose of government, then payments are required to be paid, of course, by central government or authorized person to that exclusive licensee, and it shall be shared between patentee and exclusive licensee, like how we discussed in the previous slide about the share between the patentee, assigner and assignee in such proportion as may be mutually agreed between the parties. What happens if they don't agree? High Court will intervene. And with regard to any expenditure which they have already incurred in developing this particular invention or in making payment to the patentee other than the royalties or any other benefit. So what is the actual cost? That will be determined, decided and agreed upon between the parties. We move on to the next section, acquisition of patent, section 102. By virtue of a notification which is published in Official Gazette, CG also has the right not only to utilize this particular patented product but also to acquire that patented product. Why? For public purpose. And as a result of acquiring, benefits will certainly derive to the buyer. So all the rights will be vested with the transferee. It will move on from the transferor or the seller. So notice shall certainly be given to the applicant or patentee because its rights are going to be curtailed and he is no longer the vested party or having the vested right in that particular product, and hence notification is mandatory. And what happens like how we discussed in 100, 2 and 3 about before grant and after grant. Here again, there is this time difference of before grant of patent and after grant of patent. Where it is before grant of patent, whatever expenditure he has incurred, you will compensate him. When it is going to be after grant of patent, then the compensation to be paid shall be having regard to the tenure of this patent, the period and the manner in which this particular invention has worked. Now we will see the situation where High Court will step into the action. Section 103 says where there is a dispute regarding exercise by central government or authorized person of the powers conferred with regard to the rights or term of usage of this invention for the purpose of government, or any amount of compensation which is payable for acquisition of the invention or patent under 102, where there is going to be a dispute, High Court intervenes. If CG is a party to this proceeding, if patentee is a party to the proceeding, petition can be made by way of counterclaim on any of the grounds on which a patent may be revoked under 64. Friends, we have already seen in our earlier webinars about what are the grounds for revocation. There are several grounds as prescribed under your 64 subsection 1, like the applicant himself is not having any entitlement to make this patent application, or it does not lead to any invention which calls for this grant of patent, or it does not involve any inventable step, or complete specification is not there, or the invention is not of any use to anyone, or it is not a patented product or process, or this particular claim is already, the valid priority claim was already there before this particular application was submitted. So we have seen several grounds for this particular revocation under 64. So this could be one such ground if CG is a party to the proceeding calling for this patent to be revoked. Why this patent shall not be revoked, and whether a party is involved in this proceeding or not. Question as to the validity of this particular patent can be raised without making a petition for revocation. So even without making an application for revocation, even without substantiating the grounds for revocation under 64(1), you could still question the validity of patent. Is the prerogative right available to central government? Then there is yet another provision under 103 which says that if the disclosure of any information by the central government is going to be prejudicial to the public interest, then they could certainly keep it confidential and disclose such particular significant matter which is going to affect the public interest only to an advocate or independent expert. So if the question arises whether an invention has been recorded or tested, tried, then the central government could certainly exercise this particular right of keeping it confidential. And with regard to the issue relating to the terms of the use of this invention, as to how long this government could use this particular COVID vaccine or drug, then HC, High Court, shall certainly determine the compensation that would arise out of this particular invention, so that the patent holder's interest is well protected. And High Court may order to refer the whole proceeding or any question of fact or issue of fact to either an arbitrator or commissioner, so that the dispute could be settled amicably between the parties. And there could be instances where I am an employee in a central government or state government or a government undertaking, and I have created a patented product or a process which leads to patent. Then the work which is done in the normal course of duties by me, if there is going to be a dispute as to who is holding the right of this particular invention, then such dispute could also be disposed of by central government after certainly following the principle of natural justice. Here comes the Supreme Court order. We have already discussed in detail about this order last week while we handled the compulsory license situation. But here, inter alia, the order also talks about usage of the COVID vaccines for government purpose. So Supreme Court, in its order dated 30th April, dealt with in detail about the distribution of essential supplies and services during pandemic. And several drugs are certainly used for COVID treatment, and this particular protocol for patents in India like remdesivir injection or tocilizumab or favipiravir. These drugs, Supreme Court has directed the central government to grant rights to other companies to specify section 99, where for the purpose of government, these companies could make, use, exercise the right or vend, offer for sale these COVID vaccines. Thus, they've interlinked the provisions of 99, 100 and 102, and Supreme Court thus has ordered this particular central government to exercise its powers because of the emergency situation which has arisen. Section 100 thus enables central government to authorize the companies to use any patented product or process for the purpose of government use. There they have clearly mentioned the material, apparatus or other article which is evolved out of the patented product or the article which is evolved out of the patented process. By this, central government could authorize certain companies to ramp up the production. Thus, central government shall certainly exercise its powers is the essence of this particular order. Thereby, the Indian corporates could start manufacturing and also discuss about their compensation terms with the patentees and the assignees as the case may be. If again these parties are not coming to an agreeable term, then High Court could certainly intervene and fix a reasonable royalty as provided under section 103, which we just discussed. The CG has another alternative to acquire the patented vaccine. So, even if they are not going to use that particular patented product or COVID drug or vaccine, and thereby allowing the Indian companies to manufacture these products so that it is easily available to the common man, considering this emergency situation, they could take optional route of exploring 102 where they could acquire these patented vaccines. Again, 103 will come into picture if they are not able to come into agreeable terms. And there is a reference drawn again to section 66, like how section 64 is referred for the grounds of revocation in the earlier section. Here, section 66 is referred where central government could revoke the patent in public interest. So, where it is felt by central government that any such patented product or process is prejudicial to public interest, then they have the right to revoke that patent. So, 66 is also being referred to, and thus Supreme Court inter alia in its order has also directed to invoke section 100 for usage for government purpose or 102 for acquisition of these patented vaccines for government purpose, to primarily the objective being to increase or ramp up the production of essential drugs, be it a manufacturer or this particular applicant or patent holder. CG's response to this particular Supreme Court order is by virtue of an affidavit. In response to this order, CG submitted an affidavit on 9th May 2021. Here they say that the underlying issue here is only the availability of raw materials and inputs, and thus additional permissions or additional licenses may not result in ramping up the production immediately is the essence of their response. And therefore they say the matter of sending the proposal for invocation of provisions is under section 100 for using these products, COVID vaccines for government purpose, is already under process. And they also quote WHO declaration that this is a pandemic and not an epidemic, and where there is a surge in these cases and in demand of these vaccines all over the world, the solution needs to be made only by having diplomatic talks and not otherwise. And thus, any exercise of statutory power by central government could be counterproductive is the message which they have referred to in this affidavit. And thus, the exercise of powers would have serious and severe adverse consequences in the country's efforts while being made on global platforms. So, thus they say that it could be sorted out at an executive level stage, engaging at diplomatic levels, and not by exercising the statutory powers of central government as provided there. And finally, we will conclude with the Delhi High Court's order. We already discussed in the previous webinar about Rakesh Malhotra versus Government of National Capital Territory of India and others. Here, the High Court, in essence, has underlined this particular emergency situation, and they have thus ordered that this particular ramping up of production is certainly required of all these COVID drugs and vaccines. Not only that, they say that central government shall certainly look into this and take immediate action and report the progress considering the exigency, and thus they have considered various matters relating to this COVID outbreak, and due to this emergency situation, CG is thus directed by High Court to invoke the powers under Section 100 for using the patented inventions for the purpose of government. Friends, with this we are concluding chapter 17, which deals predominantly with the patented products which are used or acquired for government purpose. And we have also referred to the current scenario where the COVID vaccines and drugs, there is this particular plea and the order issued both by High Court and Supreme Court for usage or acquisition by this particular of all these COVID drugs and vaccines for government purpose, and we will wait and watch as to what exactly is going to be the outcome of all these orders which are passed. Thank you very much, friends. Take care. Stay safe.